We have to take two sets of considerations. One is how fast the DOGE Committee jumped into this, maybe acted a little prematurely, perhaps didn't communicate as best as they could. But we have to weigh that against the evil and the problems that they were trying to solve. The courts aren't biting on these claims. It seems instead to be a lot of hyperbole, a lot of exaggeration, driven to cause fear, or perhaps out of envy and distrust of the wealthy and the powerful in America. Well, the Department of Government Efficiency, DOGE, has been hit with a host of lawsuits. One of the lawsuits says that an unelected, unaccountable billionaire, you know him by the name of Elon Musk, holds too much power. Another lawsuit says that wealthy and powerful individuals are accessing private and confidential information of average Americans. But is it a cause of action to be a billionaire serving in the federal government? Is there any merit to these lawsuits? Today we're in Potomac, Maryland, walking by the Potomac River, a nice calm area, to delve into these suits and figure out what's real and what's exaggerated. Let's jump in. What is DOGE? I suppose is a central question we have to examine. There were a lot of rumors and a lot of inconsistencies when President Trump first announced its creation. Well, as it turns out, President Obama had created an executive subcommittee of sorts called the U.S. Digital Service, with an eye on protecting our digital infrastructure and making it more efficient. The executive order that President Trump used to create DOGE was simply a renaming of a vehicle that President Obama had already used. So DOGE is the former U.S. Digital Service. He's also created a temporary DOGE group that operates within various executive agencies to bring efficiency to federal government operations and to maximize their operation. So who can be part of this sort of a committee? Regular federal employees, of course, can be part of this, but the law also envisions that consultants, otherwise private employees in the regular market, can serve a role here, paid or unpaid. Federal law puts a limit on their managerial authority and exactly what they can do. But then federal law also, in a somewhat complex way, allows for temporary government hires to come on to help the president in the first year of his administration bring his policy into action. These special government employees are able to act in this capacity for limited durations, and they have less regulations and less rules that apply to them. So it becomes very complex very quickly about exactly who's allowed to be hired and what rules and laws apply to them. Now we're going to talk about the first lawsuit that was brought against DOGE. This is by the state of New York and a total of 19 states and their attorney generals. The root of their claims is that the DOGE actors were not being properly trained in how to use and process confidential, sensitive financial information of citizens in particular states, bank records, tax returns, other personal identifiable information. And under a whole host of laws then, that this would raise claims that they would be able to act and stop DOGE from potentially acting in a way where those records might be leaked or might be destroyed or might otherwise cause harm to citizens of these states. So what did New York and the other states have to say about this? Well, the first claim that they said was the Privacy Act enacted by Congress protected state residents and their private banking information. and that if you have poorly trained DOGE employees, that information can be easily leaked. Second cause of action was in the Tax Reform Act and in Treasury regulations. Those place limits on how government may be able to access and use tax return information to be able to prevent that from being shared publicly or getting leaked. There's also the E-Reform Act in Congress that placed limits on government. Whenever it enables new technology, it has to make sure that it's acting in a way that's secure and it won't distribute information in a way that might harm citizens. Now, there's a crucial factor to each of these causes of action: the Privacy Act, the Tax Reform Act, and the E-Government Act. All of them only apply to individuals. And the problem that we had here is that states were bringing the claims. There is not a single individual plaintiff named. Now, if I was the lawyer doing this, I would have added on a couple of taxpayers who were upset about this. But guess what? I wasn't involved in that lawsuit. So all of these three claims were initially shot down by the court in the Southern District of New York because as a state, you simply are the wrong actor to do this. That's pretty bad lawyering. And I don't think that those claims have any chance of surviving any final determination. We're at an early stage here. This is what's called a preliminary injunction. We're just looking at the early take on the case and whether any sort of early relief can be granted. So far, poor lawyering, bad claims. Now let's move more into the New York and other state challenge here in the Southern District. Separation of powers. That's that old doctrine from the Constitution that says what's the power of the executive is the executive's and what is that of Congress is Congress. And it gets really murky about what exactly New York and the other states are claiming here. Essentially, it's that somehow rich individuals who are serving on the committee might somehow be blocking congressionally apportioned funds to be able to go out. But no state was able to make a showing that particular funds had been blocked or injured. Okay, so next step is separation of powers. It gets sort of murky in the complaint, but the essential claim here is that, look, Elon Musk knows rich and powerful guys. They're part of the DOGE Committee, and they are somehow acting to block congressionally apportioned funds, and that constitutes a violation of the separation of powers because the executive branch, President Trump, can't block what Congress, the part of government ordinarily entrusted with spending decisions, is able to do. But problematic to the state of New York and other states' claims was that they could not point to one single funding stream that had been actually disrupted, that where Congress's will to fund a particular program had actually been damaged or destroyed. That's fatal to any sort of a claim where you have to be able to prove an injury. And so that was shot down too. There's an interesting clause in the Constitution that's rarely adjudicated called the Take Care Clause. You find that in Article 2 of the Constitution. And that says that the President shall take care to make sure that laws are faithfully executed. Now, most courts say, similar to the Ninth Amendment and other curious parts of the Constitution that are hard to understand, that's non-justiciable. We really can't make sense of what that is and how you would craft a cause of action about that. But some courts have allowed it where you show that a president is stepping way beyond his line of authority. And, but it requires a very objective test in a serious showing. And because the state of New York and other states made bare conclusory allegations here, that claim too was shot down. Let's move on to the second lawsuit. Second lawsuit finds itself originating in the DC District Court, federal court. It's 14 state attorney generals challenging the Trump administration and DOGE that through its cutting of certain grants, certain spending programs and the like, that it caused real harm and injury to individual states and their very ability to function. As Washington State put it, with the proposed cuts and threats of funding streams drying up, that it doubted that it would even be able to serve, be able to take care of its legal obligations to its citizens. New Mexico said that by the DOGE Committee acting in a way to disrupt funding streams, that they would be subject to embezzlement and cyber theft, probably. And the state of Connecticut went further and said, with cuts to its funding streams, maybe its Department of Social Services wouldn't be able to fund vital programs in the state. So we have a host of maybe, what ifs, hope nots, as the basis of this lawsuit. Now, as any decent lawyer knows, when you come in, especially to be able to prove crucial statutory or constitutional claims before a court, you have to have a redressable injury for the court to be able to move and provide relief. Standing, the very notion of standing found in Article 3 of our Constitution, requires that to be there. And saying that something could happen, might happen, is an imaginary fear that we have down the road is simply not enough. And what that means, usually, is that a law has been brought prematurely. It hasn't ripened on the vine. We don't know what the real effects of it are. And so the court immediately knocked down, the DC District Court knocked down this 14-state coalition. So it had no basis to be able to make these claims because there was no real injury before it. Now again, this is in the context of a preliminary injunction. We're at an early phase, but to me it sounds like this is ripe for a motion to dismiss, for the case to disappear. Without standing, you're wasting the federal judiciary's time and its resources, something as we as lawyers should take very seriously, and it may amount to a frivolous lawsuit in that sense. Now, we're going over a lot of material, and I want to be a straight shooter with you. Not every court has come down this way. There's an interesting case called Doctors for America, and that challenged the information that was made available on the CDC's website, on the FDA's website. They won, at least for a very limited sort of relief, actual remedies that certain websites had to be put back online. So no way I'm saying that this has been a clear win for Trump in every instance, but as to really deep-reaching claims sounding in their theories about these unelected billionaires doing great danger to the heart of a republic, none of that's been bitten into by any court, including the DC District Court here in this 14-state coalition lawsuit. That's problematic for those who are sounding these alarms about a crisis in our republic and causing some skepticism about their alarmism. Number 3, let's get to the third lawsuit. Public Citizen, Democracy Defenders, and Federal Union brought a lawsuit against Trump and the OMB about whether DOGE constitutes what's called a Federal Advisory Committee. And if so, then certain procedural requirements, note-keeping requirements, public record requirements all attached to this and have greater scrutiny for its operations. Let's see what that looks like. So what does the Federal Advisory Committee Act, FACA, require? So if you have a FACA committee that's in place, what this means is that if you have an individual who is not a federal government employee who's serving on that certain requirements get triggered. Things like when you have a meeting, it has to be published in the Federal Register, that the public has a right to be able to attend, that certain very express minutes are made available to the public about this, and then that the composition of this committee represents a fairly balanced set of views. Balance of views, that's a difficult one. It doesn't mean that the president, in setting out DOGE, has to have a perfect balance of views, just that a reasonable amount of views are accommodated. Now, you'll recall if you watch my TikTok video, I talked a lot about judicial deference, and I think that's a growing problem for folks on the left and folks on the right. And if you're particularly worried about DOGE and this committee, then you'll be sad to hear that courts traditionally apply a great deal of deference to what the president says is needed to represent a fairly balanced committee. You see there's an anti-hunger coalition case that sets out this standard if you want to learn more about that. But essentially, courts are not going to jump in and try to micromanage who is on one of these FACA committees. Instead, they're going to give a lot of room for the executive to make that determination. Now, there's lots of interesting ways to be able to operate one of these committees without triggering the requirements. And we've seen this happen historically. One way is just to make sure, as the statute says, that every single member of the committee is actually just a federal employee, that no special rules apply. Here's another trick. When you start up your FACA committee, operational or implementation teams are not considered part of that committee. So for some time, you can have outside actors, private consultants, driving and setting priorities within a particular committee. And if they're labeled implementation or operational consultants, then they're outside the reach of the law, and the special transparency requirements don't apply. You can have a host of special temporary government employee designations apply. This has been done in the past. So let me bring up two historical examples. 1993, Hillary Clinton, the First Lady to President Bill Clinton, had a presidential task force on healthcare in America. It was very controversial at the time. Some critics called it an attempt to socialize the American medical system. And there was a lawsuit that had been filed by the American Association of Physicians, and they challenged that this was a FACA committee and that it needed to be able to have public access. People needed to be able to attend meetings, to be able to see the actual notes of what was going on there. And this went through litigation, and the DC District Court, eventually DC Circuit Court, reasoned that, well, first off, Mrs. Clinton, though not an actual government employee, she wasn't paid, didn't have any real role, seemed to be the functional equivalent of a federal employee, and that would fit the purposes of what FACA said, so no special requirement met there. We had a lot of healthcare private executives who were coming in to save their skin and make sure that they weren't going too far on this. Well, those were just temporary consultants bringing their expertise. Though they were there almost all the time and seemed to have a significant outsized role in what the committee was doing, the labeling of them was given a good deal of deference, that they were simply temporary consultants who were there. So by using either a special government employee designation, a temporary government employee designation, or by stretching the common definition of what a consultant might be, the government's figured out ways to maneuver around this. You might not like that, but this isn't new to Trump. This is a ploy that has been done by the left and the right for decades. And the reason of this video is to explore that a little bit. And it's not just Clinton. I'm not just picking on Democrats here. President Bush did the same thing with Vice President Cheney, who oversaw their own commission. Now, I'm not just picking on the left here, because both parties do this. In 2001, President Bush gave the power to Vice President Cheney to have a national energy task force. And its job was to look at national energy policy and to be able to craft a new policy that was secure and better for America in whatever way. Now, the Sierra Club and other organizations filed suit saying that this seemed to be a FACA committee and that they had the right to be able to attend, to see the notes, to do all these things that transparency in FACA was designed to accomplish. And essentially, the litigation gets very protracted, and eventually it dies out because the committee itself simply ends. It never reaches any resolution. But the way that the proceedings were going was essentially the federal government and Vice President Cheney saying, well, sure, we had oil executives coming in, just as Mrs. Clinton had healthcare executives coming in, but they're temporary expert consultants. They're not members of the actual members of the committee. They might be there a whole lot of the time, but they're just part-time temporary consultants, and we want to hear from them, and that shouldn't trigger FACA requirements. Now, we never saw an end, of course, to that particular litigation. I think it probably would have gone the same way the Hillary Clinton litigation did, and that's to say we're going to defer to the executive. You call someone a consultant, they're a consultant, they're not a member of the committee, and we're not going to impose these stringent transparency requirements. So, America, please don't be too shocked right now to learn that although you may have tech entrepreneurs and individuals coming in lending their expertise, if they get labeled as consultants, because the courts have continually blessed this approach, and I wouldn't expect any different result here. Meaning, third lawsuit, non-viable, gets dismissed. So part of me, and I hope part of you, wonders about why the proliferation of these lawsuits when they seem to have so little basis in law or reality. And one of the psychological things that I wonder about is it's very popular in the human spirit, and particularly in America, to have a distrust and hatred for the very wealthy and the most successful among us. And I wonder how much of this, with Elon Musk leading this DOGE innovation, is really just this summoning of this populist hatred for those who achieve the most in society. Sometimes we have this rather unfortunate zero-sum thinking about economics and how well people do. And if a high-status person is out here, that somehow they must be diminishing what I'm doing in life and how far I can reach. I think nothing could be further from the truth, but I think that's unfortunately a psychological reality for many Americans. After all, we've seen this happen before. Rockefeller with Standard Oil was called a robber baron, but he's the guy who founded and funded the University of Chicago and many cultural institutions. Carnegie, with his steel empire in America, was also an industrialist that Americans love and they love to hate. He brought us our library system, he brought us many cultural institutions, and he was also wealthy at the same time. Elon Musk carries a similar imprint, and I would hate for this, I think, skewed perspective to somehow destroy the good efforts of DOGE simply because people are upset about the person who seems to be the standard bearer and the engineer behind all of these efforts. I think we can do better than that as America. So the summation of all this is pretty simple. The lawsuits that I've talked about are very big on sizzle, short on substance. We've seen similar tactics done in previous administrations. I mentioned Hillary Clinton being in charge of a fairly radical overhaul of the American healthcare system, and similar tactics being used. So we shouldn't be too surprised that they're upheld here today. We also know that of the courts looking at the heart of these claims, that there's an unelected individual seizing power, destroying separation of powers, and violating key financial privacy statutes. The courts aren't biting on these claims. It seems instead to be a lot of hyperbole, a lot of exaggeration, driven to cause fear, or perhaps out of envy and distrust of the wealthy and the powerful in America. Now I want to be really clear to say, if the hyperbole, if the PR releases about these lawsuits were true, we should all care about that. If we had unelected powerful men breaching into average Americans' privacy and sharing that with malignant actors or just not being careful with that data, we should all care. But the thrust of these lawsuits seems to be based more in exaggeration. It seems more a use of lawfare to destroy a duly elected president rather than to bring actual justice for constitutional grievances. And that's something I think we should all care about. Now here's a balancing act that I want you to do in your head. We have to take two sets of considerations. One is how fast the DOGE Committee jumped into this, maybe acted a little prematurely, perhaps didn't communicate as best as they could. But we have to weigh that against the evil and the problems that they were trying to solve. And that's a federal government that's drunk on unaccountable spending and prone to abusing its own power. Now, a group I've done some work with, Open the Books, has done terrific work at bringing accountability to spending problems at the federal government. It's reported in 2022 that the federal government's made some payments to some 2 million dead people that account to $3.6 billion in a year. Insane. Then there's a Small Business Administration that paid out to 57,000 groups under the Paycheck Protection Program who were listed on the Do Not Pay program, over $3 billion. That's absurd. How about the National Institutes for Health? They doled out $500,000 to study, can you guess it, how and why pigeons might gamble. And that same group, another $500,000, to study something pressing in every American's mind. How do animals defecate? Animal toiletry, folks. Or here's this lovely gem. Dr. Fauci's Institute of Allergies and Infectious Diseases spent the same amount, $500,000, studying, could we make monkeys transgender? Folks, even the Government Accountability Office, part of the federal government, says the feds are losing somewhere between $250 to $500 billion with a T, in fraudulent or just mistaken spending every year. So Americans should be outraged about the state of fiscal insanity going on at the federal government. And if the DOGE Committee is coming in and maybe it's kicking cans a little hard at the beginning, maybe it's missing a couple procedural steps, I think you have to weigh that against decades of fiscal insanity and a sense of betrayal from the American people. I think the courts are going to catch up with DOGE and be able to cure any of the procedural mistakes that are made. And I'm sure that there will be some corrections, some course corrections that come. But as to the heart of what DOGE is doing and the executive power to be able to carry it out, courts don't seem to be biting. And I think at the end of the day, we're just going to see a minor corrections on these suits and no grand constitutional controversies coming out of this. Now, I want to be clear, of course, we can all do better. I can do better at these videos every week. I hope I'm bringing you something better. We're learning about this. And I think the DOGE folks could probably do a little better here too. Better early communication to the public about what they were doing and how they were executing their tasks. Yeah, I think that was probably called for. Maybe a little more measured of a stance at the beginning, a little more thoroughness and planning, probably called for. But I salute them for their overall energy at tackling something that no prior administration has seriously dealt with, and that's important to do. So let's watch as these lawsuits proceed. I think we're going to see them fizzle on all of their substantive grounds, and I think we'll see minor course corrections that DOGE will have to follow going forward.